The property division in a divorce in Texas is what the state calls a just and right division. A lot of people colloquially will say, I just want my fair share. I just want my fair share. Fair is like the other F word in family court, okay? So we don't really talk about what's fair, but we talk about what's just and right. So if the parties are going to divide their estate, what is the just way under all these circumstances in order to divide the estate? If we look at not just the behavior of the spouses, certainly if one spouse has been cruel or one spouse has wasted a bunch of money gambling or something like that, that would affect how we might want to divide the estate. But what if neither party has done anything wrong? What if you just have a stay-at-home spouse for a decade? Well, if we divide everything right now, right down the middle, the stay-at-home spouse may not have what it takes to be able to survive on his or her own. So we have to account for the financial circumstances of the parties. We have to account for who's got primary possession of the children, because that's going to affect their work schedule, their work opportunities potentially. What if one of the children is severely special needs and that parent's never going to be able to work because they got to take care of this kid all the way through adulthood? All those factors factor into a just and right division. So it's much more than just my fair share. Texas is a community property state, and we presume that all of the property that is acquired during the marriage is part of the community. It's neither separate property of either party. There's what we call a community property presumption. We presume that everything that was acquired during the marriage belongs to the community. If one party wants to dispute that some property is community property, they have to rebut that presumption. They've got to prove to the court that that was their separate property. Otherwise, the court thinks it belongs to the estate and it's going to be divided in a just and right division. Separate property in Texas there's really only like 4 categories for separate property. You've got things that you owned before the marriage. You've got things that you acquire during the marriage through gift. So those would include gifts from your spouse. And then of course, anything that you inherit. So if you are in someone's will or your mom or dad pass away and you inherit part of their estate, that's yours. It's not community property. And then if you are involved in a lawsuit and you receive a judgment for pain and suffering, that is your separate property. And so we divide community property in Texas. Separate property is not divisible. So a party can't be divested of their separate property in a divorce proceeding. So if you and your spouse are getting divorced and you inherit $1 million, that inheritance is not part of the divorce estate. That's yours. So ask me, how can I screw up my separate property? And that's a bigger discussion. But generally speaking, you cannot be divested of your separate property. The duration of a marriage in Texas only has limited impact on how we divide the estate. Whether you're married for, 20 days or 20 years doesn't really affect the marital division from a conceptual standpoint. The only thing that really matters is if you've been married over 10 years, you potentially would qualify for spousal maintenance post-divorce. If you're not married for at least 10 years, generally speaking, you're not going to qualify for spousal maintenance after divorce. Of course, Texas is a non-alimony state, so you're not going to get alimony just as a result of a divorce. That doesn't really happen in Texas. So spousal maintenance could be part of the divorce, but generally you've got to be married at least 10 years to get that. The percentage and the duration of spousal maintenance, the amount of money you can get and the duration you can get does grow over longer durations of marriage. So you could get more spousal maintenance on a 20-year marriage than you can with a 10-year marriage. You can get more in a 30-year marriage than you can over a 20 or 10-year marriage. But other than that, the duration of a marriage doesn't really have any impact on the property division. Because Texas is a community property state, all the assets that are acquired during the marriage are presumed to be owned by the community. And so, say a spouse is working at a company that offers a 401k. That spouse starts accruing 401k during the marriage. All that 401k is community property also. So a lot of times we see in a divorce, someone will say, well, I want to keep my retirement. I've been working for this company 20 years. I want to keep my retirement. It was never your retirement. It was always y'all's retirement. So a 401k, imagine you stay happily married, you retire from your job, and you've got $200,000 in your 401k. You and your spouse are going to use that money during your retirement. So your spouse is going to consume some of that. So we do a divorce. The court doesn't see that you're getting screwed if your spouse gets a break of that 401k, because they were going to consume some of it anyway. So it was never yours. It was always y'all's. It always belonged to the community. Just because it came from your job doesn't mean it's yours. So 401k, 403bs, whatever kind of retirement vehicle you may have, a simple IRA, if it was accrued during the marriage, it's divisible in the estate as community property. That's just how it works. A lot of people are owners or partial owners of a business, and in Texas, if you start that business during the marriage or you buy into a business during the marriage, your ownership interest is community property. Let's say a husband goes out and opens a plumbing company and starts a plumbing company during the marriage. That plumbing company, the ongoing concern, that plumbing company is community property. Now, there's a little distinction here. The van for the plumbing company, the various tools for the plumbing company, the warehouse for the plumbing company, all that stuff belongs to the plumbing company. The plumbing company is community property. Those items belong to the plumbing company. So come divorce time, what the court will do is divide the plumbing company, the interest in the plumbing company, and typically what that means is the other spouse would get an equity share of the plumbing company. So the company is worth $1 million. We're going to break off, $100,000 to the wife or $200,000 to the wife. Whatever the equity of that firm is, the wife is going to get a just and right share of that. She's not going to get the van from the plumbing company. She's not going to get the warehouse. So the assets of the company are typically not divided. The equity in the company is divided. One of the advantages of claiming fault in the breakup of a marriage is that it could give you an opportunity for a disproportionate share of the marital estate. If the other party has intentionally screwed you financially over the course of the marriage, the court may punish that spouse and break you off a disproportionate share of the marital estate as part of a just and right division. It's just that you get a 55% split instead of a 50% split. In more dramatic cases of misconduct, serial adultery or adultery where we've spent a ton of money on the paramour, the court may award the innocent spouse a 60% share of the overall estate. So it's not a 50-50 split, it'd be a 60-40 split. Typically a 60-40 split is reserved for really egregious marital misconduct. A 55-45 split is more common if there's been misconduct by one of the spouses. But even if the one spouse has been a cheater for years, if they haven't wasted a bunch of money on the paramour or paramours, then the court may not award a disproportionate share. Make sure if you think you're entitled to a disproportionate share, talk to your lawyer, make sure you plead for that in your petition, or else you can't ask for it at trial.